Welcome to the Professionals of the Inland Empire show with your host, John Tulac.
Everybody, and welcome to Professionals of the Inland Empire. I'm your host, John Tulac, an international business attorney located in Claremont, California, which just happens to be the center of my global economy. You all have your own personal center as a business person in the Inland Empire. And the purpose of this podcast, in case this is the first one you're tuning into, is to do two things. One is to showcase our amazing professional talent in the Inland Empire, professionals who are lawyers and bankers and accountants and business consultants, all of whom are nearby and can help you and your business grow and thrive. And in so doing, the second purpose of this is to call attention to economic growth and development in the Inland Empire. We have a lot going on out here, and it's time that everybody knew about it. So this is one of the ways of bringing attention to who we are and what we do in the Inland Empire. And today I'm very, very excited and happy to welcome to the show a very special guest, a fairly new member to Provisors, Veronica Mittino. She's a former prosecutor in the county of Riverside, and she's now in private practice. But what she does and how she does it, and the area in which she does it, makes this really very, very interesting and very compelling, because she's involved with dealing with sexual abuse, both as a prosecutor dealing with crimes, and now in the private sector dealing with civil litigation, combating sexual abuse. It's a big problem with multiple dimensions, and we're going to be talking today with a real expert. So Veronica, welcome to Professionals of the Inland Empire.
Hi, John. Thank you so much for having me on today.
So let's start with how I usually like to begin this, is how you got to where you are. You know, what brought you from law school to the prosecutor's office to private practice?
That is a really good question. Like, I will share with you, when I went to law school, I knew I wanted to be a prosecutor. I knew I wanted to prosecute sexual assault and child abuse crimes before I went to law school. I used to work in fundraising and development, and I got a chance to work with different nonprofit and NGOs dealing with human trafficking, sexual assault, and child sexual exploitation. And it was through that work I wanted to have the same type of impact that those frontline workers were doing. And so I talked to my boss at the time, and I decided, hey, I'm going to go to law school. This is exactly what I wanted to do. I was very fortunate. I was able to begin working at the district attorney's office as a 1L, my 1L summer. For folks who don't know, that's your first summer after your first year of law school. I did well enough. They invited me to come back. I came back my second year, and they offered me a position as a prosecutor. I was very, very, very fortunate. And I shared back then my love of prosecuting and handling sexual abuse and child abuse cases. I worked my way up, and then I was able to do that at the district attorney's office. And then I was there for a little over 5 years. And after that, I had an opportunity to work for Slater Slater Schulman, specifically handling sexual abuse litigation, which is what I do now still. And I'm very fortunate that I have an opportunity to really help people in this particularly sensitive area of their lives, which is often very devastating and very painful for a lot of folks. So that's basically my story and how I got here.
So that is something that not every attorney can say, is I knew what I wanted to do before I even started law school, and then you stuck with it all the way through. So the term sexual abuse sometimes bothers me because it's so bland, given the wide range of things that fall under that category, from, harassment that's somewhat out of line in the workplace to real serious domestic violence and everything in between. So as a prosecutor, dealing with the different grades and types, tell us a bit more about how you dealt with the different kinds of cases and how you prepared to take those cases to trial.
That's a really good question. So sexual abuse ranges in gradation. You're going to have sexual abuse that's going to sometimes often involve words, right? Words. You can think of annoying and molesting a child under the age of 18. That can happen through various forms of touching or behavior, right? That can often seem minimal. Then you have very serious life offenses that involve the use of implements or the raping of children by the use of force or other things. So, and everything that you can imagine in between. And there are, we used to say, at the DA's office, it's very challenging we called it SACA, Sexual Assault and Child Abuse Unit. And so SACA charging in and of itself is very complicated, and it takes a little bit of time to learn. So within that specific context, there are many charges that can apply in many different situations, but usually what you're going to see, is going to involve touching or words. And as I mentioned to you before, things that will lead into that much more serious type of offense. Now, in terms of how you present the case, I mean, I've had many different cases throughout the course of my career. I've been very fortunate. I prosecuted multi-victim, in some situations, very complex child abuse cases, multi-jurisdictional, some cases. And the way that you present those cases to trial, they're not going to be the same. And every victim is very different. And it's very important to understand that not all victims are going to react the same way. Not all victims have the same disposition. Not all victims behave the same way. And oftentimes people don't like to talk about sexual abuse. And sexual abuse is not unique to one particular type of individual. It affects children, it affects men, and it affects women. And everyone in between, from every socio-economic background. And so when you're dealing with that, you have to be very sensitive, because people, they're not going to come to you most times and say, I am clamoring at the opportunity to talk about this horrific sexual abuse that happened to me, and I have to recount exactly how it happened, talk about how my clothes were, talk about how my body parts were, talk about how the perpetrator's body parts were, and all these things that, that you can imagine. That's not fun. Most people don't like to talk about, their last sexual experience in and of itself. So imagine having to talk to a room full of not only 12 jurors and alternates that you have, plus the judge, and you have an attorney who's cross-examining you on the other side. I always would tell my juries, at the beginning of every case during voir dire, you're talking about witness credibility, and there's ways to, to really get jurors to understand, right, in the appropriate fashion. But, you ask jurors whether or not they can be fair and impartial, and if they see a witness moving around in their chair or crying or not looking at you, right, if that's going to affect your ability to be fair, you're automatically going to think the witness is lying. And then you use this example about close your eyes and think about a situation in which you last had your last prior sexual experience, whether that was very intimate or whether that was horrible, and you ask them to close their eyes, and then they open their eyes, and you always choose a man, and you say, okay, Mr. So-and-so, now tell everyone in this room about it. And then you stop them. You don't want them to say anything, obviously, right? But then you ask them, okay, how did that make you feel, right? Was that uncomfortable for you? And then you go forth, right, in your examination and your voir dire about whether or not you're automatically going to disbelieve someone if they reacted the exact same way, right? And there's a way in which you do that is appropriate for the court. I've done it many times in trial, but it gets the point across, because kids don't want to talk about the obvious things. I know that we're live right now, so I'm not quite sure what exactly I can say, but it can be very, very, very graphic, and some of the things that, the kind of cases that you see. And I have a lot of respect for all of my colleagues at the district attorney's office who are still actively criminally prosecuting cases. And I'm very fortunate. I've had an opportunity to learn from a lot of really good prosecutors. My boss now was a former prosecutor in our office, and he's just fabulous. And he was also the trial team leader of our SACA unit for a period of time. And so, you prepare these cases with a lot of patience, with a lot of understanding. They're not easy. Witnesses don't show up to trial, both in criminal and civil cases.
Right.
People will recant or they're minimized, especially if they have abusers who are their family member. And oftentimes, more often than not, sexual abuse is perpetrated by somebody that the victim knows. So,
Which is truly scary. You've given some really good tips for anybody who wants to do trial work about what you do and how you get ready. And obviously you have an extra burden with this kind of case. Is you have to have a concern for the victim, the one who's got to testify, and you also have oftentimes very graphic evidence that has to be presented, not always entirely through that witness. So the balancing act that you have to do is, I think, so much harder than for attorneys doing, let's say, business litigation, where it's, you got a chart of numbers It's like, and here's the lost profit.
That's certainly, yes, that's certainly not the same case, you know. It's not about a lost profit. I will say I love doing what I do. I could not imagine doing anything else. The immense amount of reward that one gets, especially as a prosecutor, you know, when you see someone who is held accountable for the horrific sexual abuse that they have perpetrated on somebody else, and both in the civil context, when you are going and holding public and private entities accountable for their pattern and practice of covering up the abuse, systemic abuse, and then you have an opportunity to really secure meaningful compensation for victims to begin to rebuild their lives, because sexual abuse is something that never goes away. It's with somebody forever, forever. It's always stuck in the back of their mind. They're going to think about it every single day for the rest of their lives. Sometimes it'll be easier than others, and other times it won't. And it will come on like that when they're engaging in any type of, you know, um, activity, from whether they're engaging with their children, or they're going to the grocery store, they hear a song, or they're trying to be intimate with a partner, or they're at the beach, you know, or they're just lying in bed. And there is nothing that is harder when it's just you and your thoughts. And I know everybody that's listening knows exactly what that means at different points in their life for them. And so for victims who have been sexually abused, it is something that they have to contend with, and having the opportunity to be able to bring justice to them, both in the criminal context previously and now in the civil context, is something that I am extremely grateful for and feel very blessed to be able to do.
So that's a good place to segue into the prosecutor side and the criminal aspects, and how many years does this crime deserve, to the private sector side, where how much money is this case worth? Did you find that a difficult transition to figure out what to ask for? It's a very different approach, I would think. Maybe the approach is the same, but what you're talking about is very different.
Certainly very different, right? Because, you know, when you take a look at a criminal case, you have punishments that are determined by, you know, there are statutory uh, terms in which an individual is going to be sentenced in terms of prison, and whether that is going to be a determinate term, which means it's a specific time in prison, or an indeterminate term, which means life in prison, so 7 to life, 25 to life. That's going to all be laid out, and that will be affected by various charging decisions that are applicable in a particular case. As it relates to a civil case, yes, I mean, I do think that my criminal background has helped in terms of understanding various forms of abuse, types of abuse, having a wider range of experience in which to compare abuse to. But you start to look at different factors, and you start to look at different things, right, that an organization knew or didn't know, the notice or lack of notice, the adequate, reasonable safeguards that were implemented or were not implemented, basically their negligence, the negligent hiring, retention, and supervision. And then you are going to be able to factor that in, right, to the case, the damages that an individual has, and then you're gonna evaluate that. And so that can be tricky at times. I've been fortunate, as I mentioned to you before, to have wonderful people to be able to learn from, that I continue to learn from every day and ask questions to be able to achieve the maximum results for our clients.
So you're working with Slater Slater Schulman, which is a firm that does the big tort cases, the civil side of things, but class actions, you know, multi-district litigation sometimes, and so on. So obviously, there's a process to that, and you're doing some of that as well. With, I guess, the Boy Scout litigation being one example, where you're dealing with quite a few victims, you know, in one kind of common set of circumstances. So how does that work? Tell us a little bit about that process.
It's going to be, it would be very different. We have large docket cases, some that I can talk about and some that I can't talk about. One that you mentioned, which is public, and that's on our website. And then others that are individual cases against either public or private entities. And those can be against hospitals, they can be against school districts, they can be against various other institutions, colleges, universities, things like that. In terms of how it works, you know, the intricate workings of a case, it's really going to depend on how many plaintiffs there are, how many claimants there are, and whether that's going to qualify under JCCP for California or an MDL petition in federal court. So that's something that I certainly am actively trying to continue to learn, right, as I'm newer to the firm, joined the firm last year. But the process is nuanced. It's different, in the criminal system versus the civil system. And so it's really interesting having the opportunity to both civilly prosecute individual cases against public or private entities, or having the opportunity, I should say, to work on some of these larger docket cases. And as it comes, to the docket that you just mentioned, that's very fun because it incorporates a lot of what I had a chance to do as a prosecutor in terms of going to trial, depending upon which avenue in which some of these claimants decided to pursue in order to secure settlements in that case. And so there's an IRO process, and that very much simulates a trial, and it's basically a court trial. And so it's really nice to have the opportunity to do that now.
Okay. How about human trafficking? Do you do anything in that area as well, in the abuse that comes out of the human trafficking?
I don't. You know what? I have to tell you, I don't. And I cursorily touched that when I was at the district attorney's office, but really my primary focus was on sexual abuse, prosecuting the sexual abuse of children, of men, women, both in domestic violence context when I was in the domestic violence unit, and then exclusively in our sexual assault and child abuse unit. And now I primarily focus on the sexual abuse of children and adults, whether that be men or women.
Okay. So how do we stop it? We've got all these statutes that criminalize this kind of conduct. We have torts and the potential for really, really big damages for, was oftentimes such egregious conduct. And yet these problems continue, despite all the best efforts of folks like yourself. How do we stop this? Let's start with the workplace first. Is we have so many business folk listening in, and of course, Provisors is a business networking group. How do we stop this in the workplace?
I think that in and of itself is something that can be both easy and challenging because perpetrators come in all forms, right? You never know who a perpetrator is going to be. It can be the CEO and executive at the top, or it can be someone at the bottom. It can be someone that you notice every day or someone that you don't. And so I think it's important to recognize that people inherently are very challenging. I think with the proper education, that's one way in which you can handle it. I don't know if sexual abuse is ever going to go away, sadly, because it's such an insidious um, crime that has been happening for as long as I think people can think back. So in terms of the workplace, I think implementing proper procedures, following appropriate laws that are in place, having consistent training, implementing groups in which you can have employees go in a private setting and be able to talk to, which they're able to do that with their HR units. Outside of that, it really does come down, just to the saying that knowledge is power, talking to your children about sexual abuse. I know it's very uncomfortable, it's very hard to have to do, but doing your best to be able to speak to them, to talk to them about, what kind of touching is appropriate, what kind of touching is not. And that's not always going to be the end all be all, but that's one place to start. I think it's keeping a vigilant eye. I always try to tell myself that it's important, right? That I'm not overly vigilant, just given my profession. And I have a tendency to do that, just given the vast amount of cases that I have seen in the situations in which sexual abuse can be perpetrated, both in the criminal context and now in these civil cases. The facts don't change, the perpetrators don't change. It's just going to be dependent upon, where it occurs. But I think it's really important to talk to your children and be vigilant, follow the laws, implement the proper procedures at the workplace, create those safe spaces, and don't be afraid. If something does happen, you do need to speak up and you do need to speak out. As victims, it's very, very, very hard. The process of disclosure is unyielding, and I mean unyielding. It's very challenging when a victim chooses to come forward. And oftentimes they are blamed and shamed by their every word, their every choice, and their every action, as if they, rather than their abusers, were the ones that did something wrong. And they have to face the criticism and that scrutiny of every choice that they made, every action they said. Well, why didn't you tell someone? It's obvious why people don't talk about sexual abuse in the workplace? Why didn't you say something? Well, it's obvious why people might not say something, because it's not only is it hard to talk about, but you don't know how you're going to be judged, and if that person is a boss or is a supervisor. So again, coming back to that context, be very aware in the business setting of who you're hiring, the kind of situations that you're setting up, and if it doesn't feel right, don't do it. And I mean, don't do it. When you're having these social gatherings and things of that nature, just be mindful, right? Think through all the different situations that can happen, because if it does happen, you might be on the hook for that. Now, I don't practice employment law, so I can't give specific advice in that area, but generally, that's what I think of when you ask me that question.
Well, but I think that's good advice to our business owners out there is first, we've got eyes and ears in the workplace. And so employees should be aware of each other and how they're behaving, and shouldn't tolerate any kind of that bad conduct. And managers and the C-suite people can't say, well, it's somebody else's problem to manage. It's got to be a company-wide commitment to, we will not tolerate this. We have a zero tolerance for this kind of conduct in the workplace. And at least in my experience, companies that have that kind of policy in place and really take steps to make sure their employees know that we mean it, generally don't have claims. And if they don't have claims, they don't have lawsuits they have to defend, which may or may not be covered by insurance. And it's a better work environment. In the home, where the abuse is someone who's in the family quite often, that's a much tougher problem to address, because the eyes and ears aren't the same. So I don't know what you do to help make that better.
That's really hard. I mean, the eyes and ears, you're right, are not the same. And it's really hard, because victims who are abused at home, or they're abused, within an organization or institution, they have established relationships sometimes with their perpetrators. And a lot of kids don't know whether or not they're going to be believed. A lot of adults don't know whether or not they're going to be believed. And you oftentimes hear over and over again similar themes when it comes to disclosure. They're ashamed, they're embarrassed, they didn't know if they would be believed, they didn't want to be judged, they don't like the way it made them feel, and the list goes on and on and on. And when you sit and you're engaging with someone who has suffered sexual abuse and they're a survivor, you feel for them, and it's understandable why they might not come forward. And I think generally as a culture, we can change the narrative in terms of how we respond to disclosure. Rather than the victim blaming and shaming, we need to ask questions. And keep in mind, I mean, not every disclosure is true. I think it's important to recognize that too, and that's it. Then when people do come forward and they're not telling the truth, that does a true disservice to the millions of victims who are sexually abused in the United States, and just all over the world. I mean, there's billions, and so that does them a disservice. But there are so many victims who do not come forward. Disclosure in sexual abuse cases is uncommon, and when disclosure is made, late disclosure is the norm. And I think that's important to recognize. That's very important to recognize. A lot of people don't say anything for a long period of time. Sometimes that's months, sometimes that's years. And then you have folks who don't disclose, don't tell their wives until 40 years later, 30 years later, 50 years later, right? So I think if we're able to change that narrative as a culture in terms of how we treat sexual abuse victims, that can help. I don't know if we're ever going to stop sexual abuse. It was a dream of mine. I would love to be able to end that at some point and end that suffering, because it truly does cause suffering. But how you end it, you have to have stricter laws in order to deal with it. I think the criminal system has done a really nice job in terms of, its ability to bring in other sexual abuse evidence in terms of, 1108 evidence, and the domestic violence context for other domestic violence cases, it's 1109 evidence. You can also bring 1108 if it involves sexual abuse. In the civil context, I'd love to see more, right, in terms of more that can be done there. But also in the civil context, the rules are different. In deposition, it's different. I've seen carte blanche. They're asking, victims everything. And that's really hard. It's hard to watch somebody have to relive every aspect of their life, things that aren't relevant, and just this wearing down of, an individual, and often making them feel worse when all they're doing is just trying to tell their truth.
So there's a place for compassion and asking questions too, that sometimes lawyers don't understand there's value to that approach as opposed to how can I tear you apart.
Without question, and I've gotten into it many times, with opposing counsel when they're pushing that line and going too far and just blatantly um, being disrespectful and unethical, quite frankly. And there is that level of compassion that needs to be had. And there are certain rules when you are having witnesses testify in court, when you have victims who are children testifying in court. But even then, I mean, I have seen some defense attorneys really go after child victims, and it's something to watch. And yes, defendants have an absolute right to be to be defended as they should, right? They should, because at least in that system, they're fighting for their physical liberty. So I certainly understand that and I support that. But I do think that there comes a line in which one needs to be very careful not to cross. And I've seen that cross many times to the detriment of victims. And when you watch a child or you watch another human being who is on the ground and they are crying and they're bleeding from their nose because they are so just overwhelmed with stress and emotion, having to relive the abuse. They are shaking, they're having full-on panic attacks. You're going to think differently in terms of the harm that you are doing by the manner in which you are cross-examining them or the manner in which you are examining them. And I think that's really important to keep in mind, because you have to remember that every day that you're doing that, there's still another human being sitting in front of you, and sometimes that can get lost when you're in an adversarial system and you're trying to win on one side or come to some type of a resolution. And often in the criminal system, defense attorneys, they don't want their client to get convicted. That's understandable. As prosecutors, right, you want to uphold justice and the law and make sure a horrible person doesn't get out and harm anybody else. In the civil system, you want to make sure that those entities change those pattern and practices of covering up the abuse. And so you're doing all that you can on both sides, and they don't want to pay a lot of money that victims righteously deserve. So it can become very contentious to the detriment of the victim.
It can also become detrimental to the defense because it can really swing a jury. It's like, I don't like that. I don't like that at all, and they'll take that into account. That was going to be my last question, but I just thought of one more that is just kind of a curiosity question. Do you follow the celebrity cases where the Weinsteins and the Epsteins and the Diddy Combs cases, get all this coverage when there are all kinds of other cases that are similar don't? I mean, do you pay attention to those? Do you get anything out of following them?
I have paid attention right to them in the course of the news as they've come about. In terms of studying them legally, right, taking a deep dive, my schedule has just prevented me from being able to do that. But those cases, they certainly, right, the defendants in those cases absolutely deserve to be held accountable. And I know some folks think that maybe, on this last trial that, Sean Diddy Combs might not have received the justice, right, that he was hoping for. And as a prosecutor or former prosecutor, you certainly want to, convict them of all the charges that you have alleged. But the fact that he was convicted of what he was convicted of at least sets some meaningful message that that was the behavior he was engaging in, and he's going to face some serious time for that. I know the prosecutors in that case might not, be recommending a ton, but again, I have to go through and really take a deep dive. But again, more power to them, and a lot of kudos for them to going out on that case and trying to hold someone who had done something horrific to a lot of women and a lot of men accountable for what they've done.
Okay. Well, thank you, Veronica, for sharing some time with us today on a topic that I think is tough to talk about, and from an action standpoint, representing both the people or individual plaintiffs is tough to carry out. But we certainly applaud your efforts on both the public and private side of things to hold people who commit these kinds of terrible acts accountable, and raise several things that I think in future podcasts we may address from different perspectives to carry on a discussion about this is something that we just have to do everything we can to keep from happening. So thanks again for being my guest. It was very, very interesting to hear what you had to say. And for our regular listeners, and I hope that's a bunch of you now, we will be featuring 2 more people from Provisors Network next week on a topic that will be announced as we get the next set of podcasts put together. So for now, so long until we meet again. Take care, everybody.
Thanks for watching or listening to, depending on the case, the Professionals of the Inland Empire show with your host, John W. Tulac. If you have a suggestion for a guest, email him at jwtulac, that's JWTULAC, @gmail.com. jwtulac @gmail.com.